First of all, I'd like to advise you that this hearing is not being conducted in accordance with the law. NJAC 7:7-4.5E requires the notice of all CAFRA hearings be published in the DEP bulletin. We checked all of the bulletins back to June. We didn't find any notice of this hearing. So I would strongly suggest that you give proper notice and conduct another hearing at a time in the future, because this one does not comply with the law. There's a significant issue, as you've heard, regarding whether or not this is phase one of a much larger project. And I think you have to consider, we're talking about a 0.7 mile bike path. It's a lot like that bridge to nowhere in Alaska that I heard about last night. We have documents which we have provided to the Corps, some of them we've provided to the DEP, and we will provide you with others, that indicate that the real project is from 35th Street to Crook Horn Creek, and it might even extend to Corson's Inlet, where we understand the DEP has already illegally cleared wetlands, and we were told that that was part of a project to link up that area with this bike path, even though no permits have been issued. So there are significant questions out there. We have documents from Henry Hang Chua, the architect for this project, from Totten Associates, who did the surveying, from Janetta Dix and others, referring to this as phase one, and presumably with phases 2 and 3. We have a document that says phase 3, presumably to follow. So we need to get to the bottom of this. Ocean City or its mayor or somebody needs to certify once and for all what this project is, and whether or not this is the first phase of something more grandiose. In any event, the application as you have it before you is not a complete application and needs a lot more implementation before you can even get to the point where it's complete and you can review it and make a decision. And hopefully you'll get to that completeness point before the next hearing. At a DEP pre-application conference, which was conducted for this project on July 28, 2005, the city was told by DEP staff that an alternatives analysis would be the key to a project in wetlands and wetlands buffer. And we have a summary that Ms. Dix was kind enough to provide us of that meeting, which she wrote. And she wrote in the summary that, quote, "The only way the NJDEP will approve the proposed bike path is to include a detailed alternatives analysis in the CAFRA permit application," end of quote. Why then does the application that was filed with you contain absolutely no discussion of alternatives? This is a very significant deficiency. For CAFRA applications involving wetlands, the rules require a discussion of alternatives, including the no-build alternative. And you've heard a lot of reasons already tonight why it's not necessary to even do this project. It can exist just the way it is in the future. So in this application, there's no discussion whatsoever as to why a bike path needs to be located in the middle of the wetlands, or why it can't be moved to existing streets, or why it's even necessary. Now, the city characterizes this project as a rails to trails project. And despite what I heard earlier from Ms. Dix, it says right in their application that they're proposing the, quote, regrading and, quote, leveling of the former railroad bed. We all know that the site was a railroad for 100 years, and according to the National Transportation Enhancement Clearinghouse, which is sponsored by the Federal Highway Administration, as well as according to the Rails to Trails Conservancy, former railroad beds are likely to be contaminated with hazardous and toxic material. Likely sources of such contamination include railroad ties, which include wood treating chemicals such as creosote, spilled or leaked liquids such as oil, gasoline, diesel fuel, cleaning solvents, and detergents, herbicides, fossil fuels. You get the picture. I'm happy to hear for the first time tonight that a phase 2 was done, and we'd like to get a copy of that and to review it. And depending upon the review of that, we think it's necessary that some credible soil sampling be done to determine what's out there. Based on the history, we know that it's likely that there's something toxic or hazardous. And then to further determine what the impact of this leveling and regrading and this construction on the wetlands and the threatened and endangered species and so forth is going to be. They've done absolutely no testing as part of this application. It remains to be seen what that phase 2 shows or if that's even valid, because standards have changed since that phase 2 was done, but we'll reserve judgment on that. But we just want to let you know, we think that's a major deficiency of this application. The application proposes a 12-foot wide walkway and 3 inches of paving over the entire length of 3,680 feet. The city characterizes the area as including, quote, existing paving, partially paved, and gravel roadway, end of quote. As you've heard, it's not all gravel, it's not all pavement, there's vegetation out here. There's no indication of how much impervious cover is proposed, and that's important in determining the impact upon the wetlands. And in fact, we don't even have an LOI indicating what the wetland delineation is, and I briefly read your preliminary staff report. It seems like you're requiring that, and that's a good thing. In terms of wetlands, the regulations require the city to demonstrate that the project is water-oriented or requires water access as a central purpose of the activity. Water-dependent. Bike path is not water-dependent. It also requires that there's no prudent or feasible alternative on a non-wetland site. There's been, as I said, no alternatives analysis. You need to require one. They also need to demonstrate that the project will result in minimum feasible alteration or impairment of natural tidal circulation and minimum feasible alteration or impairment of natural contours and natural vegetation. None of this is addressed in the application. As Jill Lomax, our environmental consultant, who signed up right after me and will speak next, as he will discuss, we think the city has vastly understated the extent of wetlands which will be impacted by this project. It's failed to address these criteria, and we would hope that you would require them to come back to you with a complete application. DEP's own landscape maps indicate that this site is smack in the middle of threatened and endangered species habitat for at least 8 species, including black-crowned night heron, least tern, black skimmer, and others. Under DEP's rules, development in threatened and endangered species habitat is prohibited. Prohibited, unless the city can demonstrate through a T&E impact assessment that the species will not be adversely affected directly or through secondary impacts. They've submitted no such analysis. I applaud you. I looked at your preliminary staff analysis, and you're requiring them to do that. That's a good thing. As Mr. Lomax will talk about in a few minutes, this site is also critical wildlife habitat, and it's the site of many diamondback terrapin nests. The city has even failed to mention diamondback terrapins in its application. DEP's mapping indicates that a water body immediately adjacent to this site is designated as Category 1, which is the most pristine classification of waters. And a map showing that, it will be included in the report that Mr. Lomax is going to hand to you in a few minutes. Under the regulations, Category 1 waters shall be protected from any measurable changes to the existing water quality. So they have to demonstrate that what they're doing is going to have no impact on these waters. And this gets back to the soil testing issue for hazardous and toxic materials. In addition, the entire project is within the 300-foot special water resource protection area adjacent to Category 1 waters. Development within this area is only allowed where the applicant can demonstrate that the functional value and overall condition of the special water resource protection area will be maintained to the maximum extent practicable, and in any event, the special water resource protection area cannot be reduced to less than 150 feet. They're going to be hard-pressed to demonstrate that what they're doing is not within 150 feet of Category 1 water body, according to DEP's mapping. So there are many deficiencies to this application. We hope that you will require them to supplement the application with additional study. You've already indicated as to wetlands and threatened and endangered species that that's going to be done. I hope you do it with respect to these other policies. As of right now, this is clearly a candidate for denial. And Joe is next on the list, and he will address the environmental. Thank you very much.